Hatred for your country or its administration is no less than an act of treason. Sedition laws have provisions that have been misused several times in the past. But are they entirely unnecessary? Recently, the Law Commission of India, headed by the former Chief Justice of Karnataka High Court, Ritu Awasthi, has submitted its 279th report that recommends retention of Section 124A of Indian Penal Code, which criminalizes sedition, albeit with certain amendments. What is Section 124A and why has the Law Commission recommended to retain it? Let us try and answer these questions by giving you a little historical perspective on this provision of IPC. Hello and welcome, I am Shreya and you're watching the Pamphlet. IPC or Indian Penal Code is the official criminal code of India that defines crimes and provides guidelines for punishment for almost all kinds of criminal and actionable wrongs. It covers all the criminal aspects from nuisance at public places to murder, rape, dacoity and what not. Section 124A in the IPC defines sedition as either spoken or written words, signs or visual representations that attempt to bring hatred or disaffection towards the government established by law in India. It also seeks to punish the offender with imprisonment for life. When IPC was drafted in 1837 by Thomas Macaulay, sedition was included as a part of Section 113, but was later omitted only to be included back in 1890 as an offence under Section 124A of IPC through a special act. Its provisions were extensively used to curb any political dissent during the independence movement. The main aim behind the induction of this law was to prevent the opposition from propagating any cynical thoughts in the public domain. Even the Constituent Assembly debates held sedition as an exception to the fundamental right to freedom of speech and expression that is guaranteed in the Constitution. Although several members disagreed and the word sedition was not included in the document. A major ruling in this discussion was whether to include sedition law as a part of the IPC statute book or not, was taken during the 1962 case of Kedarnath Singh versus State of Bihar. The 5 judges bench under the then Chief Justice B.P. Sinha upheld that any incitement of public disorder or a call for violence against the government would be labelled as sedition, and no mere sloganeering that is unaccompanied by any threat to public order could be called as sedition. Not only the sedition law but various acts in the past like UAPA, TADA and NSA have prevented the commission of offences targeted towards the state. Although these mere counter-terrorism and security laws are not sufficient to abolish the sedition law, as they carry more stringent provisions. Now currently, Law Commission of India has recommended to retain this sedition law in IPC with certain amendments in the latest report that it has submitted. The foremost proposal is that the essence of Kedarnath Singh versus State of Bihar case should be incorporated in Section 124A. A preliminary inquiry would be ordered by a police officer before registering any FIR for sedition. Model guidelines would be implemented in order to curb the misuse of Section 124A. The punishment for imprisonment would be increased from a current period of 3 years to 7 years or life imprisonment along with a fine. New words like tendency to incite violence or cause public disorder would be added in the provisions. As per the statement by the Union Minister Arjun Ram Meghwal, the recommendations in the submitted report are not binding and only after consultation with all the stakeholders any final decision would be taken. This committee to re-examine Section 124A was formed by the Union of India following the Supreme Court order of May 11, 2022, wherein the court directed the central and state government to refrain from registering any FIRs related to sedition and also suspend all the continuing investigations related to it. Induction of Section 124A back in the IPC is crucial to retain the sovereignty of India and the threats that exist to India's internal security. Only after ensuring the security of the state can one guarantee the freedom of its citizens. Also, the argument that it is a colonial era law, hence must be repealed, doesn't appear to hold good. If that be the virtue, the entire framework of the Indian legal system is a colonial legacy. Thus, this does not validate the case for its revocation. Now the question here is, will the incumbent government be able to generate a consensus to retain the law? It will be interesting to think what the opposition leaders come up with. What if they think that the retaining the law will prevent them from their unjust criticism of the government, especially on foreign soil, which has been the case in last several years. Thank you for watching. If you like the content, do like, share and subscribe to our channel, The Pamphlet.